The Valley Current.
Hey, Steve, how's it going?
Hi, Jack.
Great.
I was just reading the news. There was a shooting at a Trump rally.
I know, it's crazy shit.
Two people dead, but Trump is okay.
Yeah, Trump looked like the bullet grazed him, and there was blood coming from his ear, which is a little strange that the shooter missed. But I guess there was a shooter who was not, quote, a rally attendee, which must mean he was located somewhere other than the rally. And then there was a rally attendee that sounds like an innocent person that got caught in some crossfire, right? That's what it sounded like.
Well, these are exciting times we live in. I'm just glad you and I are fine.
You got to barricade yourself in. It's like you have to get yourself a safe room or something, right? It's like
Indeed.
that. You have to be careful. So I wanted to talk about the CTA, this Corporate Transparency Act, because there's so much going on. And you mentioned something the last time we were talking about how this anti-Chevron decision on administrative law was likely going to affect, or potentially could affect, the Internal Revenue Service. But it also will affect all these other regulatory agencies that are out there. And this FinCEN, F-I-N-C-E-N, agency that exists within the federal government, it issued these regulations. I don't know if it's part of the Department of Treasury or if it's part of some other department. I couldn't quite get to the bottom of that. But it's got these regulations, and now it's issued a bunch of frequently asked questions about what's exempt, what's not exempt, because in theory, even though there's a constitutional challenge to this new sort of regulation, the view is that corporate lawyers and business lawyers, and presumably accountants that take care of businesses, have to remind their clients that they have a duty to file online a disclosure of who are the beneficial owners of the corporation or the LLC.
That's right.
Right?
That's right. FinCEN over the past decade has been responsible for a lot of the overseas reporting about foreign financial accounts over 10,000 or 75,000 or 150,000 in value, depending upon your exact situation. And the latest is that now they're trying to keep track of who owns businesses.
And not just overseas, basically everywhere, right?
That's right.
Throughout the world, right? I mean,
well, it's every business that's organized through a state filing, and that's below basically large corporation status.
Right. So just conceptually, just for the audience that doesn't realize this, the 50 states of the United States and Puerto Rico each have their own filing systems for creating entities. And you create an entity by paying a filing fee and filling out certain information. Most of the time it's done online. Years ago, it used to be done with a paper filing. Now you can actually do it online. There are services that will do it for you pretty quickly, pretty inexpensively, and as non-lawyers, like LegalZoom. And you essentially pick the state that you want to use. Most times people pick Delaware, because Delaware, of all the 50 states and Commonwealth of Puerto Rico and other possessions that we have as the U.S., let's just call it the 50 states plus, it's considered the most modern version of corporate law and corporate governance that exists, although Elon Musk has challenged that and moved his company successfully from Delaware as the place of incorporation to Texas. And he moved the headquarters from California to Texas, to Austin, Texas. So the interesting thing is that we've had a traditional state practice for what gets filed, what gets disclosed, and so on. But now we have this new layer of federal law that essentially says to the states, we don't care if you like to keep information private. And Delaware is a state that does keep information private, as is Nevada. California tends to be more disclosure oriented, which is why a lot of people no longer incorporate in California. But now this federal statute and regulation comes in to essentially say, no, you have to make a disclosure of BOI information, right? Beneficial ownership information, which I assume lots of people, including, for example, Donald Trump, bless his soul that he survived the assassination attempt, if that was it tonight, have lots of LLCs with very opaque information about who is a beneficial owner. So I can't even imagine what the Trump filing is going to look like if they ever get made, right?
Thank you for that explanation, Jack. And I should say that my practice has not really yet involved a lot of these new Corporate Transparency Act or CTA filings. Let's say that I have 500 clients and 100 are businesses, but only 10 are new businesses that have been started this year. And so for the 90 older businesses, well, some are sole proprietorships that aren't affected by this because they don't have to file a state paper. And the others wait until December because they're not new. So far, only the new businesses have had a 30-day or 90-day deadline.
90-day, 90-day.
Yeah.
And for a lot of new businesses,
this is brand new, is what I'm saying, and nobody really knows how it's going to work. And they're just saying that even businesses that have closed already this year have to file. So they're trying to make business.
Which is really strange, because when you look at what happens in a defunct business, it basically has no assets. It can't pay lawyers. It can't pay accountants. It has no reserves, typically. It could have a body of patents that are sitting around waiting to become public domain if no one takes any action to pay the fees or do anything to keep them alive. There's a lot of them. There's many, many such businesses. And oftentimes the founders and the various investors, including the venture capitalists, will just walk away from it. Like it's an abandoned automobile. Like, yeah, it used to run, we used to take gas, we used to operate, but basically we can't afford to continue to have it operate. It may still look like a car. It's technically an entity. Sometimes the bank account is even alive, but there's no money in it. And so the real question is, who owes a duty to do what might be called the wrap up? And if they can't afford, because it's not like dissolution is that simple of a process, there's a series of steps you have to go through. Who's supposed to do all those steps if there's no money to pay for it? It's almost like board membership becomes a new liability if the board members are supposed to actually take care of the burial. Like you could think of it as many people just won't bury their dead carcass zombie companies. They'll just leave them on the street to kind of wither away. And people wondered, is it still in existence? Does it have any assets? I mean, there's lots of stories like that where corporations exist, but they've been suspended for non-payment of taxes, for non-filing of annual reports. And there's no real information about who the beneficial owner is. And there's no one to do it. And these regulations, the latest view of these regulations are, somebody's got to do it. I assume they're taking the view that the directors that were last on the board of directors, but most directors will resign pretty much when they see the ship going down. They just don't want to have the responsibility for dealing with it. So I don't know what that means generally for what one does if you were the lawyer for such a failing entity, or you were the accountant for such a failing entity, because I don't think the lawyer or accountant owes that duty. I don't think you signed up for that. Maybe you have to exclude that from your representation agreement to make it clear that you're not. But I don't know who does the work.
With my usual disclaimer that I'm not an attorney and nothing here is legal nor tax advice. See a specialist about your particular situation. But here I am practicing in California. You practice multi-state, and to a small extent, I do also. But I do not encourage my clients, if I get involved early enough, I do not encourage them to organize in California. The three most popular states, in my experience, are Wyoming, Delaware, and Nevada. And in these states, oversimplifying a bit, when you're done, you just send them a piece of paper, a signed piece of paper saying we dissolve. And that's it. And at that point, if anybody comes to you with questions about the business, to the best of my knowledge, you can then tell them the business no longer exists. I'm not an officer. I have nothing to do with this.
Right.
And you're done. But here in California, it can take years to wind down and tens of thousands of dollars in professional and other fees to wind down a business, like you say.
Right.
And many people just walk away from the carcass. And so that's one of the reasons why I discourage organizing in California. The other being that if you hit a home run here in California, California takes 12% off the top. And if you hit a home run and you're organized elsewhere, you can then move out of California, sever your connections, which is a complicated, lengthy discussion,
right,
and save that 12%. So, but you can also dissolve instantly in most other states, whereas here in California, it's going to be an extended and expensive wind down process.
Right.
And now you're subject to the CTA reporting.
Right. But CTA is broader than just California, right? So your point is that because the dissolution process is so complicated, you're going to have to file, and you can't just say it's dissolved, whereas perhaps you could say in the simplified Delaware filing, the simplified Wyoming filing, what was the third state that you like to use? Nevada?
Nevada.
Simplified Nevada filing, the business is dissolved. There's no beneficial owner. Because there's no owner. It's basically defunct. There's nothing there. Now, if there are some patents, and typically there could be trademarks, there could be patents, there could be copyrights, other intellectual property, and it hasn't been handled in a dissolution, it's not automatically in the public domain. That's what many people misunderstand. It's not like, well, if you dissolve the entity, with that simple filing, take the case of Nevada or Delaware or Wyoming, very simple filings, it's dissolved. The patent office doesn't say that must mean that the owner of the IP is now the public domain. There would have had to have been some pre-dissolution affirmative filing that said, we hereby abandon our IP rights. Now you might say, well, isn't it obvious if they're dissolved? But technically, I think the underlying state law, even in those three states, Delaware, Nevada, and Wyoming, would be the assets devolve to the creditors. So if the creditors want to figure out a way to, divide up those assets, which is often a problem because you have to get someone to do the work. And it's not like it's free. It's not like someone's going to say, oh, I'm going to do this work for free. And there are professionals that are called assignees for the benefit of creditors, because usually there is a creditor class before even the shareholders get paid, the creditors get paid. So, it's an interesting problem because maybe ultimately those people would file, the creditors would file as beneficial owners if they wanted to get access to the patent rights. Like they're the ultimate parties, particularly secured creditors, would come first. This whole thing raises so many questions about who is supposed to do what and when.
It does. It does. Let me throw in another grenade and say, let's say that you're married, as many people are married, and it's an S corporation.
Right.
And now you may think as the wife that you're the sole owner of the S corporation, but you may be sorely mistaken if it was started using community funds, or if your husband benefits from the income of the corporation, then he was also supposed to sign the original S election. And if his signature was missing for whatever reason, then your original S election was invalid. And the IRS has a no excuses policy.
Really?
And by now it's too late to correct the S election retroactively. So in fact, a corporation was really a C corporation, and all 20 years of taxes need to be refiled as a C corporation instead of an S corporation.
Have you had that case? Have you actually had
Yes,
that case? That is such a wild case, because most people think, like, somebody comes in, whether a man or a woman, they're the founder, they're married. And if you're a good, competent lawyer, you have to ask, are you married? Yes. Has your spouse agreed? Yes. What are you using? Separate property, community property, blah, blah, blah. You go through all that list of questions. And your point is, it's a trap for the unwary that if they're married and there's even an argument that community funds were used or community labor, community services were used, that changed the characterization of the corporation to one that is really community property owned by the community property estate, the election should actually be filed by both husband and wife or both spouses.
Even if the property is truly separate property, then the IRS regulations still can be read to require both signatures.
So does that mean there's no way for one spouse to fully disclaim ownership? Like if the spouse starting the business says, I have a prenup, I have this, I have that, I have another disclaimer, my wife is signing off, my husband is signing off, this is my business, it's my gig, it'll always be mine. You're saying even in that case, the IRS comes in and says it's trap for the unwary, but you really should have your spouse do the election for the sub-S election.
The spouse signature needs to be on that piece of paper, even if it's a 0% ownership, because the spouse potentially benefits from the income produced by the business. And a lot of people miss that, and I've seen that, and there's court precedent on that. And the precedent and the IRS policy is no excuses. The S election has to be perfect, but they don't tell you that it's wrong. Until 10 years later, by which time it's too late to fix it.
Wow.
And
so now blend in the idea of a, disclosure of a beneficial owner in a harmonious way. There would be a suggestion from that IRS practice that the other spouse is a beneficial owner, even if they haven't signed off, even if they've disclaimed everything, they should be listed as a beneficial owner. Put differently, if there's a super strong prenuptial agreement between, say, Donald Trump and Melania Trump, and Donald is forming an S corporation, LLC, whatever he's forming, it seems like the safe thing for him to do would be to include that Melania might have a beneficial interest in this, even if it's intended that she not have any such beneficial interest. On the theory that she's been taken care of through the prenup in some fashion, presumably with other cash or other assets.
There's been this recent Supreme Court issue about wealth taxes, and you're on top of that. And a big piece of that is that as corporation participants all consent to the S election. And so the recommendation that I'm hearing is that even for somebody who we think it is not an owner, they still should have their signature and consent on the S election, listing a 0% ownership interest or zero share.
Is that true if the entity initially starts as an LLC and all
Absolutely.
It's still
even if it's an LLC that's electing to be taxed as an S corporation.
Right, but an LLC, even without the election, is viewed as a partnership, right? Isn't it viewed just by default as a partnership? Like that's just the default rule. It's not a corporation, right? Just generally.
Yes, the LLC is a partnership, and if it's a pure partnership with no S election, then a whole different set of rules.
Right.
In case law
So people
applies.
should know, by the way, or we should tell them, Wyoming was one of the first states to pass legislation creating this idea of a limited liability company. The LLC Act started, the very first LLC Act started in Wyoming. And the view of the Wyoming legislature at the time, and it's a small state, I want to say maybe there's 500,000 people maximum in the whole state, in a world or a nation that has 330 million people. It's like 500,000 people, maybe. It's not even more than a million. So it's a tiny number. It's like less than 1/3 of 1%. It's probably even less than, 1/6 of 1% of the entire US. But they wanted to take care of their ranchers and their business people that were operating in Wyoming with a much more simplified approach to limiting liability, which is what they did. And they made all the forms, I'm told, I don't practice in Wyoming, but I'm told that they made it very simple for people to get a Wyoming entity formed and to get a Wyoming entity dissolved. So here's the point I want to make. If Wyoming says to the feds, we're not going to have our corporations and LLCs disclose anything. We have privacy laws. I don't think Wyoming will do this, but in theory, Nevada could, I suppose, and maybe Delaware could. Will we have like a state fight versus the federal? I mean, federal law typically preempts a state in areas where there's an intention to do so. But will we see some states say, just ignore them? We don't care what you do. We like the idea of privacy. And Delaware has historically respected privacy, which is why a lot of people use Delaware, as has Nevada. I think to some degree, Wyoming has done so too, but probably to a lesser degree. But do you see my point about the eventual potential conflict between states' rights and privacy rights of owners versus the government coming in and saying, no, you got to disclose all that, including Donald Trump?
And there's a lot of people out there who want to keep their affairs private. Maybe they have an ex-girlfriend who's stalking them.
Mm-hmm. Right. Well, it's often the case that the best way to protect yourself against claims is to have the appearance of not owning anything. The very first thing that someone will do if they're trying to collect a debt is to look around to see whether or not the person that they're targeting owns any real estate. Because that's been the traditional asset that really can't move that fast, right? Because you can't move the real estate. But, coins can be moved, diamonds can be moved, all sorts of personal property can be moved, and often is moved pretty rapidly. So if the real estate, if the person's name is not on the real estate, and these days for most wealthy people, it's not their names. It's typically some LLC, often with a very opaque name, that you can't even tell who owns it. But these beneficial owner reports are going to disclose who actually owns that LLC. And in theory, that's going to be a publicly available piece of information, right?
And it's going to be an ongoing annual reporting requirement, even if nothing changes. And so just as with Delaware corporate filings, every year I get paid, $500 a pop to deal with the Delaware renewal website and to calculate a small tax, often $600, sometimes more, that is based on either number of shares or total assets. Now, some people get that wrong, and they calculate their Delaware tax based on depreciable assets, which is a misconception. It needs to be calculated based on total assets. But be that as it may, every year, ka-ching, $500.
Right.
And even though nothing has changed.
It's like buying the insurance policy for the limited liability. It's viewed as okay. That franchise fee or that statutory fee is viewed as okay. What gets upsetting in California is when people get the additional annual tax on their revenue, like the additional tax return that's actually resulting in an annual tax that's based upon how much turnover has happened. And I forget what the cap is on the LLC, but there's some cap to the overall tax. It's like an enhanced statutory fee based on the turnover being above a certain number. Do you remember what that is?
I don't remember the exact details.
But it's not inexpensive. I think it adds like another $5,000. Like it's not just the statutory $500 fee. It becomes like, oh, your LLC is doing really well. We get to tag you for another $5,000. So
yes, that LLC fee is significant, and there's a floor to it. Many of my smaller entities are just below the floor, and they're not affected by it. But yes, if they're over that floor, it's a significant cost. Now, that's a downside to the LLC. Another downside is the complexity. And you mentioned LLCs being simple. My perception is that an S corporation is usually simpler than an LLC because there isn't a lengthy agreement between the owners of the LLC, the members of the LLC, the way there is between the shareholders of an S corporation. So oftentimes, if somebody comes into my office wearing blue jeans and there's no attorney, I will suggest an S corporation, not an LLC, because everything is much simpler. It's the vanilla flavor, whereas with an LLC, you can customize it a lot, but then every year the professional has to read all the customizations and make sure they're doing the right thing, and that adds cost to the situation. But so again, so far I have not had to deal with many of these things. I've been referring my Corporate Transparency Act potential clients to a firm called E-Minutes that has so far done over 50,000 Corporate Transparency Act filings at a cookie cutter price range. But mind you, they're not necessarily expert consultants in how to keep your affairs private. Right. And for a client who'd be wanting services consultation in that area, I'd recommend you, Jack.
Well, I don't know that I have the answer, to be honest, because I do think this is an evolving area and some lawyers are more aggressive than other lawyers. I mean, most corporate lawyers tend to be pretty conservative and they tend to sort of take the view, just file and comply, unless there's a really good reason not to. But there are other lawyers that are like, look, it might be unconstitutional. Let's create some trusts and pretend that the trusts are basically owners and not say much more about the trusts. Just say trust 1, trust 2, trust 3. Now you have to create the trusts, right? You have to actually do the work, and of course that's an additional fee for a client. But I don't know what they would say. Whether they would say, well, that's still opaque. Who's in the trust? But trusts are not corporations. So is there a CTA that applies to the trust?
My understanding is that the CTA does include most trusts.
So any type of organization, even if it doesn't have a statutory filing, because a trust doesn't. A trust is essentially a private document. The only filing it would get would be a tax ID if it's an irrevocable trust. Most trusts these days are revocable, and they're designed to act as will substitutes. And you could put any name you want on a trust. It doesn't need to be the trust of Jack Russo. It could be something like, ABC Holdings Trust, right? You can name a trust whatever you want, and it wouldn't necessarily disclose who the beneficiaries are. So there's lots of ins and outs to this that I have to believe will keep the trust lawyers, the corporate lawyers, and maybe to some degree even the tax lawyers, and maybe the accountants too, pretty busy figuring out, well, where's the loophole? Where's the thing that we can do that legitimately discloses enough, but doesn't disclose everything? Because there are lots of examples, and Trump is a good one because this came out in his latest trial, the one he lost. He has like 600 LLCs, and some own portions of others, and some are owned by others, and it's a really convoluted web. And they're just different LLC names. And some of them don't even mention the word Trump. Most of them do, but some of them don't. And they all have different partners. And can you imagine what those filings would look like and what they would end up really disclosing if they really had to disclose everything that's out there? I mean, it'd be just such an interesting process of figuring out who's involved with him in all these entities, right?
So my recollection of that trust question is slightly cloudy. It could be that trusts are only affected to the extent that they own an LLC or an S corp that has a state filing. So go to your trust attorney to get the lowdown, the skinny.
I mean, what's going on is there was a lot of publicity a few years ago about how difficult it was often to figure out who was behind a Delaware corp, because Delaware has some pretty strong privacy laws, and their corporations code allows filings that don't disclose who the beneficial owners are. And often they don't even disclose who the directors or officers are. Now in California, there's an annualized filing or every 2-year filing that has to disclose the board members and the officers, including the CEO, the CFO, the secretary, and so on. And that's a required state filing. That doesn't exist in certain states. They're okay with the opaqueness that exists so long as the annual fees are paid. So this federal statute and regulatory regime comes in to overlay all this and say, no, we really want there to be transparency. That's really what we want. We want to know who's behind these entities. Okay, now at some point, does it create a situation where people will go to overseas entities and say, I don't want to be part of the US. I don't want to be subject to US law. Figure out a way to do that. Figure out a way for us as beneficial owners not to be disclosed. It'll be interesting to see if that's what plays out, because there are certainly some countries that will highly respect privacy and will make it something that is an advantage for them from the point of view of getting that corporate business, right? I mean, that's what I would think to play out.
If going overseas, I just want to flag that the IRS does consider most irrevocable overseas entities similar to a trust to be an overseas trust, even if they do not contain the word trust in their name.
Right.
And so many clients that I've seen miss that and fail to comply, and then come to me with tens of thousands of dollars in back penalties assessed because they didn't realize, hey, I own a trust, or I'm a beneficiary of a trust and I need to report it.
Hey, Steve, thanks for coming on. Let's come back to this once we see how some of this litigation plays out. And why don't you tell the audience how they can reach you by phone and by email?
Thank you, Jack. I concur. You can reach me by phone at 408-887-6433, by email at srabin, that rhymes with cabin, SRABIN at srabin.com.
Hey, thanks, Steve.
For having me on this.
Have a good weekend. Talk to you later. Take care.
Be safe.
Tune in next time on The Valley Current.